write to the committee on or before 9th of December, and that is this month. So KRA, I believe, will respond to his grievances by 5 p.m. 9th of December. So they are still within the timeline, according to the letter that was done by the committee.
Are they going to write to you, the committee, or to the member?
To the committee.
So you will then
transmit, or rather invite the member for, or communicate to the member on what KRA will.
We'll serve the issue to the first week upon resumption. Yes, Wamboka?
Honorable Speaker, these institutions of government must also respect the rulings delivered by the Speaker. This you had directed 2 weeks ago that they bring the statement. Yesterday, 2 days ago, you still directed, Honorable Speaker. I think it is the highest time that we must have a policy where government institutions respect this House. Honorable Speaker, the issue at KRA is not a small issue. As we speak today, KRA is running like a bandit institution, Honorable Speaker. We have someone in the name of a chairman who is harassing every other employee of KRA, Honorable Speaker.
That chairman is not able to defend himself here. I won't allow you to go that route.
Okay, I'll not go that route, Honorable Speaker, but KRA needs the attention of this House. Things are not sitting pretty well at the KRA, and it's only this House which has powers to deal with the issues of KRA, Honorable Speaker. So, much as I'm guided, Honorable Speaker, I hope by January, when we resume, February, or if we have, you have just indicated that you will call us for a special sitting. This is a serious issue, Honorable Speaker. I beseech that you direct Honorable Karemba to be ready so that this House can deal with issues of the KRA and the people who are rogue.
Very well. Karemba be like the 5 wise girls in the Bible. Remember the set of 10, 5 fools and 5 wise. So be like the 5 wise ones. Come ready. Okay. Maloli Njendi, on the issue of the closure of the boarding schools.
Mr. Speaker.
The questioner, Osoro, is not here.
Yeah.
But go ahead.
Yeah, the question was raised by Osoro, which was in 3 sections. The first part was to have a comprehensive report or response on 1, the cogent measures, reasons for closing those many schools at such short notice, and whether inspection was conducted at the lapse of the notices of closure to confirm compliance, and the measures put in place to mitigate the inconvenience caused to learners, parents, and the schools, considering that the short period remaining before reopening of schools for the commencement of the 2023 academic year. Honorable Speaker, the total number of schools with boarding sections in our public and private primary and junior schools are 3,199. Public schools are 1,436, while the private schools are 1,763 in number. During the period leading to the closure exercise, the schools were inspected against the guidelines of the Schools Safety Manual 208 and the 348 schools, which translates to 10.9% were found to have contravened the guidelines, hence putting the safety of the learners at risk. The schools were recommended for closure because of the following reasons. 1, registration status. Majority of the schools were not registered as having boarding sections and therefore were operating illegally. Number 2, compliance to safety standards in the dormitories, most of these schools had dormitories with grills on the windows which provided no exit in case of an emergency, single exit doors with no provision for emergent exits, doors that opened inwards, hence compromising safety of learners if locked inside. Some of the dormitories were repurposed, buildings such as dining halls, classrooms, and workshops, which had undergone modifications without approval from the relevant authorities such as public health, public works, and NEMA. Congestion in the dormitories was common in these schools, and the spacing of 1.2 meters between the beds was not adhered to. The learners were sleeping on double-deckers and triple-deckers, while some had wooden beds, which is a catalyst to fires in case of emergency. Majority of the dormitories in these institutions had not adhered to the needs of learners with disabilities. Number 3, status of sanitation and water. The sanitation facilities in most of these schools were poorly maintained and inadequate. They had not adhered to the ratio of 1:25 for girls and 1:30 for boys. In some schools, toilets did not have doors, and in some cases, the shutters were not age appropriate. In the closed school, sanitation units for boys and girls were located in the same direction or area. Most of these schools did not provide treated drinking water for learners. Fire safety and equipment and materials. In most of these schools, fire extinguishers were not serviced regularly. Other firefighting equipment such as sand buckets, hose reels with water and smoke detectors were not available. Status of security systems. Some of these schools, the fences were porous without gates. Some gates were not manned by CCTV cameras, which had not been installed in the boarding area as required. Boarding registers were not regularly updated. Most heads of these institutions were not residing in school as required, and most schools did not engage female night security guards to take care of the security needs of female learners. Instead, there were male guards for girls. The schools had not engaged wardens to look after the boys in their dormitories at night. The status of safety in the kitchen and dining hall. In most of these schools, kitchens had poor drainage, inappropriate solid waste disposal, and unsuitable chopping surfaces. Most dining halls did not have adequate chairs and tables, while in some instances, where furniture was available, they were not age appropriate. Most cooks and food handlers had no valid medical certificates. Consideration of learners' welfare. Most schools had admitted boarders who were in pre-primary level. In some of these schools, learners were not provided with balanced diets. There were no sick bays nor qualified nurses employed to take care of sick learners. Some of the schools which had swimming pools did not adhere to safety standards in terms of construction and maintenance. On the second question, whether inspection was conducted, response.
How long is your statement, Malulu?
This one is a short one. These two, very short. The schools which were inspected were given the recommendation that they were expected to implement. They were advised to seek re-inspection through the sub-county offices once they are complied. The period to be re-inspected was to be determined by the school's rate of compliance. The third question, the measures put in place to mitigate the inconvenient cost. The schools which will have complied will be issued with registration certificates, and the learners will not be affected. However, where there will be lack of compliance, the learners will have to be placed in other schools by sub-county directors or be day scholars in the school. Thank you, Mr. Speaker.
Thank you. Next order. Nabi, you want to...
Thank you, Mr. Speaker.
The owner of the statement is not here, but I'll allow you to seek a clarification.
Yes,
and that will be the only one.
Yes, Mr. Speaker, I must tell you that I'm very, very disappointed. That is a very poorly crafted statement that does not tell us the problems in boarding primary schools. Mr. Speaker, I want to say this, that this inspection was done after the Endarasha fire. This is impulse management by Minister of Education that cannot be allowed, Mr. Speaker. Despite the fact that the owner of the statement not being here, and this is being a matter of national interest, Mr. Speaker, I would request that you order that the ministry gives us an appropriate answer detailing plans on how to manage, transition the children who are in those schools. Noting that, Mr. Speaker, a child who is registered on NEMIS in one school cannot be easily transferred to another school, especially if he's after grade 4. Thank you, Mr. Speaker.
Dawood, on the same issue?
Yes, Mr. Speaker. Mr. Speaker, the statement read by the Vice Chair. Mr. Speaker, this country has got many boarding schools. And if we go to all these boarding schools, they may be even worse than what we have been given, because there are 2 schools in my constituency. I wish, Mr. Speaker, they did a comprehensive audit of all the boarding primary schools in this country. Mr. Speaker, there are sometimes you can even wonder, how can a grade 4 be in a boarding school? We should have a policy where boarding schools should exclusively be for a little older children, not small ones who cannot. But Mr. Speaker, I'm a product of a boarding school. I've stayed in a boarding school for 6 years. But Mr. Speaker, the boarding schools of today are pathetic. There is no space to move. They are bundled up 2 or 3 on a bed, on a high-decker bed. There is no space. The door to exit is probably locked, or it's not opening the right way. The windows have got bars on them. So, Mr. Speaker, it is not just these schools should be victimized. We should have a comprehensive report on all boarding schools, not just the ones which have been banned. Thank you, Mr. Speaker.
I want to go to the next order. Let's let Mama Dagoret wacha tuachie hapo. Call the next order. Which one? Order Malulu, which one? It's not on my list. Which one is that?
Mr. Speaker, it's a response to a statement sought by Honorable David Kiplagat.
David?
Kiplagat.
He's not here. It's not on my list either. Yes, Minority Chief Whip.
Thank you, Mr. Speaker. Mr. Speaker, sorry, and I seek your indulgence. I know we are not yet in that order, but could I please know whether the Assisted Reproductive Technology Bill is going to proceed?
We have, Honorable Millie, we are going to that order now. We'll go into committee. The first on the list is startup, followed by persons with disabilities, then assisted reproductive.
That's why I sought your indulgence, because, Mr. Speaker, what it basically means is if the chair, in the morning it came up and the chair and the vice chair were not in the house. And if it proceeds and they are not here, I'll be sitting here waiting for something that's not proceeding, and I'm supposed to be in Nyanza. So if I'm just sitting, no, I just need to know if they are not here, I'll cancel my trip and sit here and proceed.
Honorable Millie, as a leader in the House, you're obligated to be here whether you have business to transact personally or not. So this is a sitting day. Your matter is listed, but even if it wasn't, I expect you to be here, regardless. More so that you are the whip. but it's on the list. I appreciate, if, for example, you have an emergency and you want me to take it out of the list, or those who are responding to issues are not here, I take it out of the list and save it to the next term, because the earliest we resume is on 11th of February. Pardon?
Respond. Thank you, Mr. Speaker. Mr. Speaker, we actually have an event in Migori, but if the chair or vice chair are willing, we have an event tonight. If the chair and the vice chair are willing to proceed, I am willing to cancel, and I'll sit here. So the only thing I'd feel sad is that I cancel and there is nobody here. Because I was supposed to have gone in the morning, I cancelled.
From where I sit, Honorable Millie, I have no capacity to know if they are here. The whip majority is Dr. Bukose around, or his vice chair? The vice chair is there.
Speaker, we are willing to proceed with the bill.
Okay. So, may I call out the next order?
Order number 11, Committee of the Whole House.
Members be upstanding.
In the Committee of the Whole House, the Start-up Bill, Senate Bill number 14 of 2022.
Clause 7.
Is there an amendment to it? We call him. Honorable John Kiarie. Honorable members, I propose the question that Clause 7 be part of the bill. The Honorable John Kiarie.
Honorable Chair, I want to propose that Clause 7 of the bill be amended by deleting it in its entirety. And why I seek to do this, Honorable Chair, is because the role of the registrar shall already have been taken up by the Kenya National Innovation Agency. And this is the agency that is responsible for the registration of startups under this Act. As a registrar, this innovation agency would be better positioned to track the progress of startups, maintain a database of registered entities, and evaluate the impact on the economy. This data would help in shaping future innovations and policies. And also, Honorable Chair, we are not here as a house to duplicate duties. If a duty is already allocated to an agency, then we have no business using this piece of legislation to create another entity to do exactly the same. As it is, and I had said this in the morning, the issues we're prosecuting here sit across very many sectors: technology, education, youth, innovation, and now trade. And so we do not want to have a place where we are duplicating this role of a registrar. Thank you very much, Honorable Chair.
Honorable members, I propose the question that Clause 7 be amended as proposed. Honorable members, I put the question that Clause 7 be amended as proposed. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? I want to put the question again for clarity. Honorable members, I put the question that Clause 7 be amended as proposed. Will as many as are of that opinion say aye? Aye. Will as many as are of a contrary opinion say nay? Nay. The nays have it. The chairperson trade to move committee amendment.
Thank you, Mr. Honorable Chair. I propose to move the amendment as it appears on the order paper, that is by deleting the clause and substituting it with a new clause. And therefore, the justification for that is to enhance clarity on the registration of labeled startups, and this will assist the startups to leverage on the benefits of the granted startups. Remember, Chair, we are moving on from clause 6, where we are already created the startups, and we have already set up the labeled startups. So if we do not carry this amendment, then it will be difficult for then registration of new startups as labeled startups. Thank you.
Honorable members, I propose the question that clause 7 be amended as proposed by the chairperson trade. The Honorable Undo.
Chair, I want to support the amendment, and probably KJ is busy or transacting other businesses. I think when we sat with the State Department in respect of this matter, they say the innovation and startups can emanate from any sector. So that's why the purpose of setting a multi-agency startup committee instead of a registrar. Actually, the amendment of the committee is a better provision than what you are thinking about. So I think this should adequately cover your fears such that we go as a multi-agency. It's not just it's not a one person. It's not a one-man show, so that it can come from anywhere, from innovation, science, from anything else. Even music can be a startup. I can decide to start my Adungu band, and so you start up or whichever, and then we move on. Thank you, Chair.
Thank you, honorable members. I now put the question. Yes, the Honorable Irene Mayaka.
Thank you, Chair. Chair had actually pressed the intervention to catch your eye. I just want to also support the committee amendments because, as I said before, having had an opportunity to engage the committee as a co-sponsor of the bill and having had their justification of why we really need to have this, I concur with them because we need to ensure that we are leveraging in totality on the benefits of startups in relation to the specifications that have been given on their registration. I therefore support the committee's amendment.
The Honorable John Kerry.
With the fact that my amendment has suffered, I would also want to put it on record, Honorable Chair, for us to note, and even for the committee to note, that not all startups are trade startups. And the reason why we needed a registrar is because, and we needed it to be domiciled at Kenya Innovation, is because Kenya Innovation is actually sitting at a very proper place to cover all the sectors, and it is going to the presidency. When we reduce it to the MSME, what will happen is that we will be moving ahead imagining that all startups are trade and entrepreneurial startups. So we end up losing out while we think we are gaining. Thank you very much, Honorable Chair.
Honorable members, now do allow me to put the question, and I therefore put the question that clause 7 be amended as proposed by the Chair Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, allow me therefore now to put the global question that clause 7 of the bill as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 8.
Honorable members, I propose the question that clause 8 be part of the bill. The Chair, Departmental Committee on Trade.
Thank you, Chair. As I proposed Clause 8, I just wanted the members to note that this startup bill and the agency will be seated, all the agencies will be seated together at the Kenya National Innovation Agency that is coordinated at the presidency, and the only role the MSME department, the State Corporation of MSME will do is to facilitate the financial production and marketing issues. So on Clause 8, we are proposing to delete that whole clause and amend as proposed in the order paper. And the reason for that, the justification is that this amendment seeks to provide obligations of the startups. Thank you.
Honorable members, I put the question that Clause 8 be amended as proposed by the Chair Departmental Committee on Trade. Honorable members, I'll repeat. Honorable members, allow me to propose the question that Clause 8 of the bill be amended as proposed by the Chair Departmental Committee on Trade. Honorable Oundo.
Chair, I think we need to be very clear. Innovation is not innovation for the sake of it. Whoever is innovating as a startup intends to commercialize, intends to make a living, an economic gain from the innovation. And that's why we concurred with the State Department's thinking that if we just left it in one office, which only registers innovation, how do you commercialize that innovation? How? Because the purpose of innovating is to make money, is to make a livelihood. So that's why we have expanded the bill from the way it came from the Senate to now look at actualization of the innovation. It's just like an architect. An architect designs. If there is no builder, it's just a design. Basic. So
Thank you, Honorable Oundo. Honorable members, it is for you to make a decision. I therefore put the question that Clause 8 of the bill be amended as proposed by the Departmental Committee Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that Clause 8 be part, as amended, be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. The Honorable Dawood, the chair did not ignore you. The chair did not recognize and the chair did not hear you. Call the next clause.
Clause 9.
Is there an amendment? Honorable members, I propose that Clause 9 be part of the bill.
Chair, I propose that Clause 9 be amended as it appears in the order paper, and the justification is to seek to accommodate new provisions on incubation provided for under Clause Part 4 of this Act.
Honorable members, I propose the question that Clause 9 of the bill be amended as proposed by the Chairperson, Departmental Committee on Trade. Honorable members, I put the question that Clause 9 of the bill be amended as proposed by the Chairperson, the Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? I will repeat the question for clarity. Honorable members, I put the question. Honorable members, you need to be attentive that Clause 9 of the bill be amended and be deleted as proposed by the chairperson of the Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The nays have it. Do you want me to repeat the question again? I told you members to be attentive. And so I'll expunge and repeat the question again. You know, Honorable Irene Mayaka, I'm putting question on your bill and you are not attentive. The chairperson in charge of ICT, I want to repeat this question for clarity. I have pronounced myself on clause 9 as the chairperson. If anybody has an issue with it, you have the avenue of recommittal. Next order.
Clause 10.
Honorable members, I propose the question that clause 10 be part of the bill. Is an amendment? The chair, trade.
Chair, I propose that clause 10 be amended by deleting as it appears in the order paper, and the justification is the proposal is in the bill in order to accommodate the new provisions on labeling and registration by the Startup Committee, which is a clause already passed by this House.
The honorable members, I propose the question that clause 10 be amended as proposed by the chair, trade. Honorable members, Honorable Nyikal, you want to?
Chair, I think what would help the mover is where you are doing a complete deletion, where we are doing, I would like the attention of the mover, where we are doing a complete deletion, it's actually better, even if it takes time, to actually read out what you are deleting. As much as I can see you are explaining, but it would make much sense to know what you are deleting. That's why we are getting there. So if we could just go through what is being deleted.
That's a fair request, Honorable Nyikal. Mover. Chairperson, could you read the provision?
I was waiting for the microphone.
You're
Chair,
proposing to delete.
I think all the clauses are in the order paper, and if we follow through clause by clause, it's in the order paper. But now that you've said I read, the clause that is being deleted is clause 10, which talks about the registrar or the county executive member, as the case may be, shall within 30 days upon receipt of an application under section 9, which examine the application together with the documents, and if the registrar considers necessary, call for such further information to carry out such inspections as he or she may consider necessary for the determination of the application, and where the registrar or the county executive member is satisfied that an applicant meets the requirements for registration under this act, the registrar or the county executive committee member shall, subject to the provisions of this act.
Honorable Chair, you can stop there. I know members already have the order paper, and thank you for directing them on the bill. Honorable members, I now put the question that clause 10 of the bill be amended as proposed by the chairperson, trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I put the question that clause 10 be part of the bill. In fact, it has been deleted. Sorry, next.
Clause 11.
Honorable members, I propose the question that clause 11 be part of the bill. It's amended. Chairperson, Departmental Committee on Trade.
Thank you, Chair. I propose that clause 11 be deleted, and I think we can read the clause 11 in the order paper, and the justification is that this new provision is already under the labeling and registration by the Startup Committee.
So we can go all of them. The Honorable Daud.
Chair, on this one I agree with the Chair, because if we have deleted 10, then it follows, this follows 10. It's the same, so we delete this as well.
Honorable members, permit me now to put the question that clause 11 of the bill be deleted as proposed by the Chair Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 12.
Honorable members, I propose the question that clause 12 be part of the bill. Chairperson, Departmental Committee on Trade.
Thank you, Chair. I propose that clause 12 be deleted, as it appears on the order paper, and the reason for this is to accommodate the new provisions on incubation provided under Part 4 of this bill.
Honorable members, I propose the question that clause 12 be amended or be deleted as proposed by the chairperson trade. Honorable members, I put the question that clause 12 be deleted as proposed by the chairperson Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 13.
Honorable members, I propose the question that clause 13 be part of the bill. Chairperson, Departmental Committee on Trade.
Thank you, Chair. I propose that clause 13 be deleted as it appears on the order paper, and the reason is that this amendment seeks to accommodate new provisions on incubation already provided under clause 4, under Part 4.
Honorable members, I propose the question that clause 13 be deleted as proposed by the Chairperson, Departmental Committee on Trade. Honorable members, I put the question that clause 13 be deleted as proposed by the Chairperson, Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 14.
Honorable members, I propose the question that clause 14 be part of the bill. Chairperson, Departmental Committee on Trade.
Thank you, Chair. I propose that clause 14 be amended as it appears in the order paper, and that is deleting that clause and substituting it with the current clause that is there, and that justification there is to provide for grounds for cancellation and registration of the Startups Committee.
Honorable members, I propose the question that clause 14 be amended as proposed by the Chairperson Trade. Honorable members, I put the question that clause 14 be amended as proposed by the Chairperson, Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 14 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 15.
Honorable members, I propose the question that clause 15 be part of the bill. Chairperson, Departmental Committee on Trade.
Chair, I propose that clause 15 be amended as it appears on the order paper, and the justification for this is to provide for procedure to be followed prior to the cancellation of registration of any startups, including issuance of notice to the affected startup.
Honorable members, I propose the question that clause 15 be amended as proposed by the Chairperson, Departmental Committee on Trade. Honorable members, I put the question that clause 15 be amended as proposed by the Chairperson, Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 15 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 16.
Honorable members, I propose the question that clause 16 be part of the bill. Chairperson, Departmental Committee on Trade.
Thank you, Chair. I propose that clause 16 be amended as it appears on the order paper, and the justification for this is the manner of cancellation of registration by the Startup Committee, and the effect of such cancellation, including loss of benefits of the startup, needs to be taken care of. Thank you.
Honorable members, I propose the question that clause 16 be amended as proposed by the Chairperson, Departmental Committee on Trade. Honorable members, I put the question that clause 16 be amended as proposed by the Departmental Committee Chair for Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 16 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 17.
Honorable members, I propose the question that clause 17 be part of the bill. Chairperson, Departmental Committee on Trade.
Thank you, Chair. I propose to amend that clause 17 be amended as it appears in the order paper, and the justification for this is to provide for an appellate process for aggrieved persons to seek review and a decision to deregister a startup.
Honorable members, I propose the question that clause 17 be amended as proposed by the Chairperson, Departmental Committee on Trade. Honorable members, I put the question that clause 17 be amended as proposed by the chairperson, Departmental Committee on Trade. Will as many as are of that opinion say aye? Aye. Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 17 be amended, no, be part of the bill. I will put the question again. Honorable members, I put the question that clause 17, as amended, be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 18.
Honorable members, I propose the question that clause 18 be part of the bill. The Chair, Departmental Committee on Trade.
Chair, I propose that clause 18 be amended as indicated in the order paper. And the justification for this is that it empowers the startup committees to keep a register of startups registered, cancelled, or voluntarily withdrawn as a startup.
Honorable members, I propose the question that clause 18 be amended as proposed by the Chairperson, Departmental Committee on Trade. Honorable members, allow me to put the question that clause 18 be amended as proposed by the Chairperson, Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, allow me now to put the question that clause 18 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 19.
Honorable members, I propose the question that clause 19 be part of the bill. Chair, Departmental Committee on Trade.
Thank you, Chair. I propose that clause 19 be amended as indicated in the order paper, and the justification for this is it seeks to allow the startup committee to alter the register by making changes and corrections that may be necessary.
Honorable members, I propose the question that clause 19 be amended as proposed by the Chair, Departmental Committee on Trade. The Honorable Dr. Nyikal.
Chair, sometimes it may be good, like in this one, if you look, they're pretty close. It may be good to point out for us just the difference. Because if you look at what is in the bill and the amendments, you can't quickly see what the difference is. And in those situations, it may be just point out that difference only.
The Honorable Undo.
Thank you, Chair. First, two things. We no longer talk about registrar, we are talking about the committee. That's number one. Number two, we have elaborated, it's a little more elaborate and concise compared to what we have in the bill here. That's the difference.
Honorable Nyikal is satisfied. Honorable members, I now put the question that clause 19 be amended as proposed by the Chairperson, Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 19 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 20.
Honorable members, I propose the question that clause 20 be part of the bill. Honorable members, I put the question that clause 20 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 21.
Honorable members, I propose the question that clause 21 be part of the bill. Chairperson, Departmental Committee on Trade.
Thank you, Chair. I wish to move that clause 21 be amended as it appears in the order paper, as it is indicated on the order paper, and this is to allow the requirement of startups to provide the startup committee with information concerning changes in particulars of their institutions, change in directorships, or any changes like the changes in where their registered office is.
Honorable members, I propose the question that clause 21 be amended as proposed by the Chair, Departmental Committee on Trade. Honorable members, I put the question that clause 21 be amended as proposed by the Chairperson, Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 21 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 22.
Honorable members, I propose the question that clause 22 be part of the bill. Honorable members, I put the question that clause 22 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Part 4.
What is out of order? The Honorable Irene Mayak.
Chair, I think you had guided that if anyone has interventions, they press the intervention button.
Yes.
I did that on 21, though it has passed.
Yes.
But please take note of that.
No duly taken.
In future, yes.
And
I don't want to be a mover of the motion that does not get an opportunity to also
yes,
speak
press
to the motion.
Interventions in good time also so that we don't bypass you.
I am very alert.
You are critical
yes, I'm
to
very
this
alert.
parliamentary process as the mover. Call it again.
Part 4.
Honorable members, I propose the question that part 4 of the bill be part of the bill. Chairperson, Departmental Committee on Trade.
Chair, I wish to move that part 4 of the bill be amended by inserting the words "and accelerators" immediately after the word "incubators." And this is basically to ensure that part 4 includes provision for incubators.
Honorable members, I propose the question that part 4 of the bill be amended as proposed. Honorable members, I put the question that part 4 be amended as proposed. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? Honorable members, the ayes have it. Honorable members, I now put the question that part 4 be amended, as amended, be part of the bill. Honorable members, I now put the question that part 4 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 23.
The Honorable Basil, you cannot intervene once the horse has bolted. Once a question is put, the time to contribute is up. I get you, and you get my direction. Yes, because after proposing the question, I wait for interventions. And by the way, if possible, ask from this. You came after I had put the question. I'm sorry for that, but the new clauses, please let us be in tandem.
Clause 23.
Honorable members, I propose the question that clause 23 be part of the bill. Honorable members, I put the question that clause 23 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 24.
Honorable members, I propose the question that clause 24 be part of the bill. Chair, Departmental Committee on Trade.
Thanks, Chair. I move to request that the clause 24 be amended as indicated in the order paper, and this is to recognize the various startup ecosystem players.
Honorable members, I propose the question that clause 24 be amended as proposed by the Chairperson, Departmental Committee on Trade. The Honorable Nyikal, you want to contribute to this?
I just want to get an explanation. The first A I can follow, because they're just changing the wording. B, we are now excluding the County Executive Committee. Would I know what is the explanation for that?
The Honorable Chairperson, could you justify the amendment very briefly?
Thank you. The startup bills is a national government function which sits at the presidency, and the reason why we are removing the county executive committee member is because this is a function that will be at the national level. The only time the county executives will be able to participate is when the startups are now being incubated in their various counties, and I think we will cover it much later in clause 30-31.
Honorable members, I now put the question that clause 24 be amended as proposed. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 24, as amended, be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 25.
Honorable members, I propose the question that clause 25 be part of the bill. Chairperson, Departmental Committee on Trade.
Chair, I wish to move that clause 25 be amended as it indicated in the order paper, and the justification for this, that this amendment is in line with the previous amendments, in cognizant to the fact that the law will be implemented by the national government in collaboration with other startup ecosystems, including the county governments.
Honorable members, I propose the question that clause 25 be amended as proposed. Honorable members, I put the question that clause 25 be amended as proposed. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 25 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 26.
Honorable members, I propose the question that clause 26 be part of the bill. Honorable members, I now put the question that clause 26 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Part 5.
Honorable members, I propose the question that part 5 be part of the bill. Chairperson, Departmental Committee on Trade.
Thank you, Chair. I wish to move that part 5 of the bill be amended by inserting the words incubators and accelerators immediately after the word startups. And the justification for this is to accommodate accelerators as they play a critical role in the scaling up of startups.
Honorable members, I propose the question that part 5 be amended as proposed by the Chairperson, Departmental Committee on Trade. The Honorable Basil.
Thank you, Chair. I want to request the mover to explain to us what she means by the word accelerator. Do you mean that this is equivalent to stimulus? Thank you, Chair.
The Honorable Undo.
As the Vice Chair prepares to answer the next, let me just assist my colleague here. The ecosystem includes startups, includes incubators, includes accelerators. Now, I want to give you an analogy. Startup, you start. Then you need somebody to incubate. And then you need an accelerator. I would have given another analogy, but I can see there are very many young people here which might not really, which might look out of place for my age, but you have understood. Even Dr. Pukosa can tell you. In fact, you can talk to him, being a medic and a gyna, he will show, he will tell you, he'll draw for you the chain. Thank you. He has understood, Chair.
Honorable members, allow me to propose the question that part 5 be amended as proposed. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 5, part 5 as amended, be part of the bill. Honorable members, I put the question that part 5 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 27.
Honorable members, I propose the question that clause 27 be part of the bill. Chairperson, is that the chairperson?
Thank you, Chair. I wish to move that clause 27 be amended as it appears or as indicated in the order paper. And basically, this amendment seeks to enhance clarity in subclause 1 and 2 through the redrafted provision.
Honorable members, I propose the question that clause 27 be amended as proposed by the Chairperson, Departmental Committee on Trade. Honorable members, I put the question that clause 27. Yes.
Honorable Chair, I'm just seeking your guidance. to know the hierarchy of the amendments, to know if we carry the chair's amendments, whether mine fall automatically. It is just a procedural question, Chair.
Yes. Before I proposed the question, I was already advised that the two amendments are independent, and the passage or the fall of the first amendment have no effect on the amendments you'll be subsequently proposing. Yeah, honorable members, allow me to now put the question that clause 27 be amended as proposed by the chairperson, Departmental Committee on Trade. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. The Honorable John Kiari can move your amendment.
Honorable Chair, I propose that clause 27 of the bill be amended as is appearing on the order paper. And the first amendment that I'm proposing is in subclause 1 by inserting the paragraphs that I have indicated there on the order paper. And the justification for this, Honorable Chair, has to do with the tax breaks that we need for key industries so that we're able to promote investment in sectors that are essential for economic growth and development. And Honorable Chair, my argument is that by offering targeted benefits, the government can drive innovation and enhance competitiveness in high priority areas. And I am sure that the mover of this bill and the chair would agree with me that this amendment is necessary and requisite. Thank you very much.
Honorable members, I propose the question that clause 27 be amended as proposed by the Honorable John Kiarie. The Honorable Oundo.
Chair, it's very well thought out amendment and very well intentioned amendment. But Honorable Speaker, Honorable Chair, remember Article 114. If you look at these amendments, Honorable Speaker, more or less reads like a finance bill. More or less. And the minister, a cabinet secretary, has no powers at all to issue this kind of tax break without making reference to the provisions in the Constitution. I would really...
Honorable Undo, your point is made. The Honorable Dr. James Nikal.
Chairman, it's just maybe, I don't know whether procedural. When I look at clause 27 in the bill, I don't see the subclause 1 that was amended previously and even now. So I don't know where the error is, because in the bill itself, it is 27, and there's no subclause 1 that is indicated. It may be an error in the bill. Yes, there isn't. Where is 1?
This.
Which bill is this?
Incentive for startups.
Yes, how come there is a difference?
Whatever document he has is wrong.
Yeah, there must be some wrong document going around.
This is the correct one.
Okay, if it's according to the correct one, then I'm satisfied.
Thank you very much, the Honorable James Nikal, for being very studious. The Honorable John Kiarie, your amendments are proposed under clause 27, subclause 1. And the amendment proposed by the departmental committee was to delete the entire subclause 1. The consequence is that your amendment has nothing to stand on, and therefore it stands dropped. Honorable members, allow me therefore to now put the question that clause 27 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. Yeah, honorable members, there was a previous communication by the Speaker that we will adjourn or stop proceedings at 5 to allow the matter concerning the proposed amendments to the constitutions to be moved and deliberated upon by the House. That being a communication, you know, I don't have powers to review it. So let us be upstanding.
You will move reporting. You will move for them
so that we move reporting.
No, we will report progress. They don't need to stand.
Yes. No. In fact, sit down. We just stop.
You will call the mover.
This is a house of procedure and rules. Once communication is made, even if it is an adjournment house, you know my hands get tied. Yes, so may you sit down so that we move reporting. I'm very sorry. Take your seats, members. Move reporting. Honorable Irene Mayaka.
Thank you, Honorable Chairperson. I beg to move that the committee do report to the House its consideration of the Startup Senate Bill number 14 of 2022 up to clause 27 and its approval thereof with amendments and seek leave to sit again.
Honorable members, I put the question, which is that the committee do report to the House its consideration of the Startup Senate Bill number 14 of 2022 up to clause 27 and its approvals thereof with amendments and seek leave to sit again. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. So we can now leave.
Honorable members, I now call upon the chairperson to report to the House. Yes, you should.
Honorable Speaker, I beg to report to the committee, that the Committee of the Whole House has considered the Startup Senate Bill number 14 of 2022 up to clause 27 and approved the same with amendments and do seek leave to sit again.
Move of the bill to move agreement with the report.
Honorable Speaker, I beg to move that the House do agree with the committee in the said report. I also request the Honorable Marianne Kaitani to second the motion for agreement with the report of the Committee of the Whole House.
Honorable Marianne.
Honorable Speaker, I second. Honorable Speaker, I beg to move that the motion for the agreement with the report of the Committee of the Whole House be amended by inserting the words subject to recommittal of clause 9. I also request that Honorable Oundo to second the motion.
I second.
Honorable members, I now propose a question, which is that the House do agree with the committee in the said report. Honorable members, I can't put the question because there's a recommittal. So the question is going to be put at an appropriate date in the future. The chair so directs. Honorable Chepkonga, you had a You had a legislative proposal?
Yes. Thank you, Honorable Speaker. Honorable Speaker, I rise pursuant to Standing Order number 114,
Number
7A. 7A. It is in the order paper, Mr. Speaker. Mr. Speaker, I rise to make comments with respect to a legislative proposal that is contained in the order paper or the supplementary paper of today afternoon. Mr. Speaker, the import of this, we are seeking to entrench a number of funds in the Constitution. Number one is the entrenchment of the National Government Constituency Decentralized Fund. Mr. Speaker, we're proposing that the NGCDF, because we have had a lot of problems with the issue of development with the courts. So we have renamed it the National Government Constituency Development Fund. Mr. Speaker, I stand here to make these comments arising from the proposal which we forwarded to the Speaker, which emanated from the legislative caucus of the Speaker. We are co-sponsoring this motion or this legislative proposal together with the Honorable Atiende Amolo, who unfortunately is not in the House this afternoon because he's involved in the East African Games and is in Mombasa as we speak. And so as I make these comments, I'm making these comments also on his behalf also. Mr. Speaker, when we met as the caucus, we reviewed these three funds, Mr. Speaker, and we felt that it is necessary to entrench certain funds in the Constitution. The membership of this particular caucus involves, among others, the Honorable Atiende Amolo, Wakili Muriu, Makali. We have a number of them, Mr. Speaker. The Honorable Kaluma, the Honorable Milia Thiambo. All lawyers are ex-officio members of this caucus, Mr. Speaker. So as we sit there, we sit on behalf of all members. So, Mr. Speaker, this legislative proposal was prepared by this caucus as a consequence of a number of challenges that we have faced as lawyers when representing the NGCDF board in defending these funds as against those members of the public who think or who consider the national government constituency development funds, the national government affirmative action funds, and the Senate oversight funds as funds that must not be dispersed to members of parliament. And Mr. Speaker, let me just give an overview in terms of what are we seeking to do. One, we are seeking for the entrenchment of the National Government Constituency Decentralized Fund in the Constitution, which will ensure that the critical role that the fund currently plays in promoting the participation of the people in identification and implementation of priority national government programs is safeguarded, as well as ensuring reasonable access to such services in all parts of the Republic of Kenya as envisaged in Article 6, sub-Article 3 of the Constitution. Two, the entrenchment of the Senate Oversight Fund in the Constitution, which will ensure that the Senate is adequately empowered and resourced to perform its oversight functions as stipulated in Article 96 of the Constitution. The third fund that we are seeking for its entrenchment in the Constitution is the National Government Affirmative Action Fund that seeks to ensure that the affirmative action groups, including women, youth, persons with disabilities, vulnerable children, and elderly persons, have access to minimum financial facilities required for the promotion of enterprise development and provision of social development services at the constituency and county levels, Mr. Speaker. Mr. Speaker, it is important for me to set out the general history of this fund. The Constituency Development Fund, Mr. Speaker, was first established under the Constituency Development Fund of 2003, and later was replaced by the Constituency Development Fund Act of 2013. Over the years, the CDF has evolved into a critical mechanism for addressing development needs of the constituencies. The legal challenges that this fund has faced over time, Mr. Speaker. Mr. Speaker, the framework has faced a number of constitutional challenges in our courts. In petition number 71 of 2013, which was instituted by Social Accountability and Other versus National Assembly and others, the High Court in its judgment delivered on the 20th February 2015 declared the Constituency Development Fund Act of 2013 as unconstitutional. The court held that the CDF Act 2013 violated key constitutional principles, including the principle of separation of powers, division of functions, and the principles of public finance. Despite the judgment, the court suspended the declaration of invalidity for 12 months to allow Parliament to enact remedial legislation or wind up the ongoing projects under that particular legislation, Mr. Speaker. Honorable Speaker, following these developments, the National Assembly and the NGCDF Board pursued or preferred an appeal against the judgment to their Court of Appeal. The Court of Appeal, in the Civil Appeal number 92 of 2015, partially allowed the appeal. However, the Supreme Court, in petition number 1 of 2018, in its judgment delivered on the 8th of August 2022, upheld the High Court decision affirming that the CDF Act of 2013 was unconstitutional. The Supreme Court held that a constituency unit of representation is not a service delivery unit, that a constituency is an electoral unit. It is set for purposes of voting for members of parliament and other elected offices. Pursuant to the judgment of the High Court, in petition number 71 of 2013, the National Assembly enacted the National Government Constituency Development Fund Act of 2015 to address the issues raised by the High Court and align the fund with the constitutional framework. Despite these efforts, Mr. Speaker, to align the Act with the Constitution, the NGCDF Act of 2015 faced a fresh legal challenge in the High Court Constitutional Petition number 178 of 2016. That is namely, Wanjiru Kikonyo versus the National Assembly and others. The High Court delivered its judgment on the 20th of September 2024, declaring the NGCDF Act of 2015 as unconstitutional, together with the amendments that were made in 2022 and 2023. All of them were declared as unconstitutional. Mr. Speaker, the High Court in its judgment stated very clearly that the constituency is not a service delivery unit. It is an electoral unit, affirming the decision of the Supreme Court that was in Supreme Court, that the Supreme Court delivered. The second thing that the High Court stated in its judgment, it stated that NGCDF violates the principle of separation of powers by assigning executive functions to members of parliament whose primary constitutional role is legislative. Again, Mr. Speaker, this was a total misunderstanding by the High Court. We made every effort to explain to them how a constituency is a delivery unit. Under the National Government Coordination Act, Section 14, a constituency has been made as a service delivery unit. Mr. Speaker, this particular section has not been nullified, neither has it been declared to be unconstitutional. So for us as members of parliament, we wondered how can the High Court declare that the constituency is just merely an electoral unit. Yet we know that there is an act of parliament which clearly states that a constituency is a service delivery unit. It is not meant to be for purposes of voting only. The second thing, Mr. Speaker, is the misunderstanding also of the High Court. That the members of parliament are the managers of the NGCDF fund. Mr. Speaker, we labor at this point, we try to tell them, but it looks like they put wool in their ears. Mr. Speaker, we all know that the members of parliament do not sit in the constituency committees. We never sit there. Two, we don't play any role. In fact, the only role we play, Mr. Speaker, is that we participate with all our voters in identifying the projects, and we all sit. We all sit. It's a public participation. That is, I'm being assisted by Honorable Alice, who knows very well what she does in a constituency in Thika Town. Mr. Speaker, when I go for public participation, I don't sit with the NTCDF officials. I sit with the voters, and I am a participant. And I also identify projects which I think the NGCDF must fund. Mr. Speaker, you know there was one question that we were asked and you know you presented this matter. And he was asked at that time, are you sure if I come to your constituency, I will not find schools that bear the name Honorable Kaluma and NGCDF? We told them, no, just come. But they refused to come, Mr. Speaker. And yet they still went ahead and stated that the members of parliament are active participants in the implementation of NGCDF projects, Mr. Speaker. Mr. Speaker, I have never participated in them. I have not opened them. When they are being opened by the NGCDF committee, I also participate also to go and hear what they are saying. And I'm very happy that they have done a good job, Mr. Speaker. The only thing I do, Mr. Speaker, is when I am around in the constituency, I do my oversight role under Section 95. As you know, the work of a member of parliament under Section 95 of the Constitution is oversight, representation, legislation, and budgeting, Mr. Speaker. And we allocate resources, and we don't go and spend. Mr. Speaker, there is no member of parliament here who walks around with a checkbook or who is a signatory of NGCDF funds in any bank, Mr. Speaker. We don't sit, neither do we appoint the fund managers. In fact, in the ruling of the High Court, they say that the term of the fund manager is tied to that one of the member of parliament. I don't know where they got that story. It is not true. The fund manager is a permanent employee of the NGCDF board. It does not hold office for 5 years. Even if he or she holds office, she holds it office at the pleasure of the NGCDF board, not at the pleasure of the member of parliament. There is a misunderstanding, Mr. Speaker, from the judiciary generally. Mr. Speaker, we have made various attempts as a house. And every time the courts find a reason. Mr. Speaker, this is the house which appropriates money. This is the house which will pass constitutional amendments. Mr. Speaker, which is this constitution amendment that is lacking in the current constitution? We have identified which they have a problem. That is the NGCDF Act, the Senate Oversight Funds, and then CAF. Mr. Speaker, we want to remove these funds from the courts, Mr. Speaker. We want to know what is unconstitutional once now they have been entrenched in the Constitution, Mr. Speaker. It is, Mr. Speaker, let me tell you, you know, when we appeared before this three-judge bench, and when we were arguing, we said that these bursaries that is being given by NGCDF has benefited very many students. It was unknown to me that the young lawyers who were in court were beneficiaries of NGCDF. When we completed our arguments, they came to us and told us, why didn't you use us as exhibit? Because we are beneficiaries of NGCDF. If there was no NGCDF bursary, we would not have been lawyers. Mr. Speaker, you can see what people are seeking to do, to disenfranchise members of our communities, the indigent in our society. Mr. Speaker, we should not accept this. We must entrench these funds in the Constitution to secure their future and secure the future of our children and our communities, Mr. Speaker. Honorable Speaker, the evolving jurisprudence underscores the need to provide a firm constitutional foundation for the NGCDF to ensure its sustainability. This entrenchment, Mr. Speaker, will provide legal certainty to the funds framework, offering stability for long-term planning and implementation of constituency-based projects, Mr. Speaker. The second thing that it will do, it will promote equitable development by guaranteeing that all constituencies, including marginalized communities, Mr. Speaker, continue to benefit from the necessary infrastructure and services that they so deserve. Mr. Speaker, as you know, Article 95 of the Constitution is extremely very clear. I don't know why the courts have a problem with it. It states, for the avoidance of doubt, that members of parliament resolve issues that are of concern to the people by enacting the NGCDF, the NCAF, the Senate Oversight Fund, Mr. Speaker, and entrenching the Constitution. We will be resolving issues that are of concern to our people, Mr. Speaker. If you go to my constituency, we have very many dilapidated schools that were built using Arambe's in those many years. Mud walls. I have seen pictures from the Honorable Marianne Keitany's schools, which are still in form of mud. So you wonder whether these are cow dens or where people go to school, Mr. Speaker. This NGCDF has assisted to convert some of those classrooms so that they can become habitable classrooms. The third thing that we are seeking to do, Mr. Speaker, is to enhance service delivery by ensuring that critical community development initiatives are implemented efficiently and effectively at the constituency level. Mr. Speaker, this is the only fund, Mr. Speaker, that is known by all Kenyans, and it has served them. We know, and Kenyans have always told us, this is the only fund which has value for money. Why? Because the management funds, the management, the fees or the salaries that is paid out of these funds, Mr. Speaker, is only merely 5%. 95% goes to the projects, Mr. Speaker. We know other institutions which I don't want to mention, and you know. 49% is used for profits, is used for management. So the only thing that goes allowances, and I'm being assisted here by Honorable Lel Mengit. He knows in his constituency he's been suffering the same thing. We know, Mr. Speaker, that it is only 51% which goes to the project. 49% is used for other purposes. And so entrenching this fund in the Constitution will ensure that we get value for money. Mr. Speaker, I want to mention 3 things why we think that this matter should be entrenched. All these funds must be entrenched in the Constitution. The first thing, Mr. Speaker, it will strengthen accountability and oversight mechanisms for the management of the fund. Mr. Speaker, as you know, without a proper
Imagine a future where you can enjoy the fruits of your hard work without financial worries. A time when you can truly relax, travel, and pursue your passions. To achieve that dream, you need to plan today. With a cost of living constantly rising and inflation showing no signs of slowing down, the money you need today will be nearly 10 times higher by the time you retire. Without a solid retirement plan, you risk financial insecurity when your active income stops. That's why saving for retirement is necessary. Regardless of your age, it's never too early or too late to start planning. Engage with experts from any RBA-registered individual pension plan for guidance in tailoring a retirement strategy based on your current lifestyle, future goals, and desired retirement age. This provides the fixed regular income you'll need after retirement to to ensure you live comfortably without compromising your quality of life. The earlier you start saving, the more secure your future will be. Start saving for your retirement today and live your golden years the way you've always dreamed. For more information, visit our website www.rba.go.ke, call our toll-free line 0800 720 300 or email info@rba.go.ke. Secure your future. Secure your peace of mind. RBA, safeguarding your retirement benefits.
Mamlaka ya ukusanyaji ushuru nchini inakuletea kampeni ya umma ya G-Nice na Risiti Legit. Thibitisha risiti yako ukitumia app ya Risiti Legit, upate nafasi ya kuibuka mshindi wa zawadi kemkem kama vile shilingi milioni 1 pesa taslim, laptops, televisheni ya inchi 50, smartphones na zawadi zingine. Disemba tarehe 4, siku ya Jumatano, kutana na msafara wetu Homa Bay katika maeneo ya Oyugis, Rangwe, Rodi, Mthiwa, Sori, Kendu Bay, Homa Bay Town na Mbita. Alhamisi tarehe 5 Disemba tutakuwa Kisii, maeneo ya Kisii Town, Ogembo, Suneka, Kanyenya, Nyamache, Marani, Masimba na Keumbu. Pata app ya Risiti Legit kwa Google Play Store au App Store kwa maelezo ya kuingia katika mashindano ya Risiti Legit. G-Nice na Risiti Legit. KRA, tulipe ushuru tujitegemee.